really honored to be able to moderate this session here on legal research and legal research strategy in international arbitration cases. Now, legal research, of course, as in any field of legal practice, whether it's domestic or international, is really key. So law determines the parties' rights and obligations and the power of arbitrators and domestic courts. And knowledge of the facts, of course, is crucial, but so is knowledge of the law. So this is a bit the starting point of this entire session. Legal research then is key to knowledge about the law, and it empowers lawyers to devise successful legal arguments and strategies for their clients to be successful in an arbitration case, or for an arbitral tribunal to provide a convincingly reasoned decision or award that will withstand both the scrutiny of domestic courts and ideally be enforceable worldwide. Many skills in international arbitration and also in international arbitration research are classical legal skills. So you need to be able to identify issues, you will need to be able to find the right rules, apply them, and come to a conclusion. Contract interpretation similarly is key. But legal research in international arbitration also differs from much of the research that you may be accustomed to from a domestic legal setting. And there are two main differences that I would like to highlight and that I think this session is also geared towards highlighting. The first difference is that the sources in international arbitration differ. So it's not only or principally legal sources from one domestic legal order, so the standard setting that you would find in doing legal research on a question of domestic law, but the sources are really much more varied and broader. So it's often multiple domestic legal systems that play a role. It's domestic law and international law. It's soft law. It's comparative law that may become relevant in international arbitration, and also the role of doctrine and writings of scholars may differ greatly from whatever you're used to from a domestic context. So the sources, in one word, differ greatly to a large extent from what you would be accustomed to in the context of domestic legal research. Second, the resources differ. Now, classical research tools in civil law are usually commentaries. They're hardly existing in the field of international arbitration. In common law, it's databases these days that help you find out case law and that help you find out whatever is actually binding precedent in your respective legal system. So, but those databases and also the commentary, to the extent it exists, is often not specifically focused on arbitration-related issues, but they're really court-focused with respect to a specific domestic legal order. And these two differences, so differences in sources and differences in resources, are what we're going to explore in this session. We have Vincent Verschoor with us. He's resident arbitration content expert at Kluwer Law International, and he focuses on acquisition, management, updating, and enrichment of content and discoverability on sources and research, legal research tools on Kluwer arbitration. Now, one of the principal resources in the field of international arbitration and in doing research in international arbitration, and also the platform that houses what we at Icar produce principally in terms of legal research material and sources. So the Icar yearbook on commercial arbitration, the Icar handbook, the Congress book, and a variety of other Icar publications that we're certainly going to turn to and see during the presentation as well. Vincent, please, the floor is yours.
Thank you, Stefan, and thank you, Young ICCA, for this webinar. And indeed, what I would like to do is show you one of the many sources that are out there. Indeed, Kluwer Arbitration is one of the better known, but it's certainly not the only one, and you should never trust just one source. So be sure to make use of other sources as well, not just Kluwer Arbitration. I am going to share my screen. So this is, for those of you who are not familiar with the website, Kluwer Arbitration. Kluwer Arbitration has been around for quite a number of years, and it started off as a collection of online publications, online books, online journals. But over time it has grown. There is now functionality on there, but it is almost online only. There are tools in place that will hopefully allow you to undertake your research in a more efficient manner. The functionality, the search functionality that allows you to go through the hundreds of books and journals that are in this database will be of use. But I want to start with the basics. So I'm just going to take you through the main content sets, show you some tips and some tricks, and hopefully we'll have some questions via the chat that we can answer, so that maybe we can deep dive into an example of some research. So as you see it on the home page, we've highlighted three of the more well-known publications, including the Icar Handbook on Commercial Arbitration. And from what Stefan and Mona have mentioned, this I still believe is one of the core items on Kluwer Arbitration. It's this comparative, multi-jurisdictional publication that is, we cannot stress how important this is. It is, whether you're researching a contract, whether you're researching evidentiary rules, whether you're researching enforcement measures across jurisdictions, this is the place to be. But as you can see from this daunting blue button, there are actually a lot of other publications, and let's have a look at those first. So the list of publications that you'll get is all the books that Kluwer has ever published, together with a number of very important treatises that we've been lucky enough to license for use, so that this is as good a one-stop shop as it can get. But again, don't trust our word for it. The list of publications is in alphabetical sequence by title, but you can play around with the date so that you get the most recent publications first, or you can get them by author. For every publication in the list, you'll have a short description of what this book is about, and how this will help you. There's some biographical information, and then of course the table of contents, where you can see who wrote various chapters and what the chapters are about. The table of contents is self-evidentary. You can just browse in, and I think this is also when you're doing reference researching. So maybe you've read an article and you know which publications are being referred to. Browsing by book or by journal is probably the quickest way, although you can search and the results should be there as well. The books list is filterable. So if you're looking by any books or contributions to books by particular people, for instance, Giorgio Bernini, you can click on that and it will list the books that have contributions by Giorgio. The same is true for jurisdictions, that you can say, listen, I'm looking for anything that covers India, and you'll see that we have a book on India. There's a handbook on Asia where there's a chapter on India, etc., etc. You'll see that the ICCA Congress is also heavily featured here, and the ICCA Yearbook, because they regularly feature court decisions from India, will also feature in here. What you can do also from this tool or this presentation is look within a publication. So you can select one or more publications and type in a search query, and the search will automatically be limited to just those publications. The interesting thing is the same. You can do the same with the three publications listed on the home page: Gary Bourne, Redfern and Hunter, and the Icar Handbook, which for many of us is almost the first place to start. What does Gary Bourne say? What do Redfern and Hunter say on a particular topic? And using the materials that they reference to then deep dive. So for instance, I could say, what do Gary Bourne and Redfern and Hunter say on evidence? And you'll see that there's quite a bit of discussion on evidence. So that's one of those things that, and we'll get to the search engine later on, where we'll be able, there's ways of narrowing down your searches. But you'll see that the only two sources that we're looking at are the publications that you selected from the homepage. The publication that I wanted to give a little bit more focus on, especially because we've been discussing the international and comparative nature of international commercial arbitration, is the International Handbook. The handbook contains, for all the jurisdictions covered, and you'll see there's quite a number, it features a national report and then English language translations of the primary arbitration legislation for that jurisdiction. All the reports are drafted in a uniform manner, so there's always the same contents, and each report covers the same content. And this is why, and there's also a link to the legislation cited in this. So if you find this national report via another means, you'll always have direct access to the relevant legislation. And again, you can go through this, compare, as you say, if you have counsel from various countries that have certain expectations, as Mona was explaining, or whether you have the law, or you're doubting the law and you want to make sure which law works to your benefit, you can use this publication. And when you're in a particular publication, you may want to use the, and this is true for all publications, that you'll see that there's a tool, or the navigation tool, that allows you to go to the previous or the next document in the series, or back to the table of contents. The journals work in roughly the same manner, in that of all the journals that Kluwer publishes or has managed to license, they are all listed here. If you have a reference citation to an article within a publication, it's quite easy. You can navigate by volume and by issue, and then by article. Each journal is introduced on the opening page with some highlights of what the journal tends to cover, what the purpose is, what the focus is of the journal, and what some biographical information for you to look into. The ICCA publications are highlighted on a separate tab, and you'll find much more here. But what I also wanted to show you is that the ICCA publications are primarily listed in the books list under ICCA. So we have here, for instance, the ICCA Congress series, where we have all 20 volumes of the Congress series, all accessible to subscribers to Kluwer Arbitration. The ICCA Handbook, which I mentioned before. ICCA Reports, which is a relatively new series, which tends to focus on important issues within the community, third-party funding, conflicts of investor-state arbitration, those kind of matters. There's a guide that ICCA published, which is intended as a handbook for judges, but it's just as well an introductory guide to the New York Convention, and then 21 years of the ICCA, sorry, 21, I said 21, it's 2021, but it's more than 40 volumes of the ICCA yearbook, where each volume, again, there's an introduction, what the volume, what the unique aspects of this volume are, but they always have, these are the most important parts, the court decisions on the New York Convention section and the arbitral awards section. The arbitral awards section, where redacted arbitral awards from around the world are published, and the court decisions on the New York Convention, where as many enforcement decisions as the ICCA can get their hands on, together with a selection of the enforcement decisions obtained from the US, are all published. So that's what I would like to say about browsing. Now let's deep dive into doing search. Well, before we do that, well, I can do that now. The search is, I think, where most of us will instinctively go to if you're used to Google. The problem with Kluwer arbitration, and this is true for any database, is that databases aren't Google. Google is too big, too widely used, too smart for its own good. So you'll have to be smarter when you start using a database. So I can type in as I said before, evidence. But again, that will give me too many results. We've given you some suggestions for, if you want to read up on treatises on evidence, so that we guide you to more high-level introductions. But you can use the Boolean operators highlighted here that will really allow you to play around with the search engine. And I'll give you a couple of examples. So for instance, Mona was mentioning that discovery and disclosure could be, in different jurisdictions, they use different terms. So you can do a search that would be disclosure, but then you can say or discovery. And that way you're looking for documents that mention either disclosure or discovery. But you can then again also use words like and or near to bring the results down again. So maybe again use the word evidence. And you can use the near functionality. The standard setting is that near means that these words are 30 words from each other, but you can narrow it down. So you can say, okay, I actually want them to be closer together. And you'll see that by using these search terms, you're bringing everything down. You can use the filters on the left-hand side to narrow it down even further. So for instance, if you just wanted to know what the Kluwer Arbitration blog has recently said on this search that you've gone for, you can use the blog filter to narrow it down. Alternatively, you could say, I am only interested in this type of discussion on maybe disclosure in India. And that, again, that really brings it down. You can play around with this.
Vincent, can I just interrupt you right here, because we've
Sure.
had a question coming through the chat saying that I'm interested in doing research with respect to arbitral awards, and so Beatrice Vitorino is asking that question. Mm-hmm. And she seems to be particularly interested in the CISG and how arbitral awards are actually interpreting it or applying it. So would the page and the search functions that you're discussing at the moment be the source for you to access or to do exactly that search? So you put in CISG or Convention on the International Sale of Goods and click on awards as the resources that should be filtered?
It depends. You can use the search engine, or you can use the browse option for awards. It really depends on which type of awards, whether you're looking for awards by a particular organization or whether you just want to search within all of the awards that we have. The search engine, in the case of doing research on the Convention of International Sale of Goods, so I could say CISG. I need to make sure that I'm also covering the Convention on the International is it the International
Sale of Goods?
So I'm at least, those are things that I'm now looking at, and then I can say, okay, I want to see how awards have quoted the CISG or the Convention on the International Sale of Goods. And you'll see there are 21 awards that we have in our collection. Again, that doesn't mean that there aren't other awards out there that discuss it in further detail, but these at least have discussed the CISG in some degree. For instance, I'm taking this decision, an ICC case. You'll see that there's plenty of reference to the CISG. It's highlighted, so you have the search. You can click on this highlighted term, and it'll take you to the section of the document that discusses the CISG, and you can then use the arrows to navigate within the document to go to the next occurrence of the term. So you can read the paragraph in this, or you can click on the full text, which would take you into the document. And then again, you can go to the first instance of the searched for term. So that's one way in which I would think I could navigate the CISG. Again, using the search engine and the search filters. And just as a reminder, so I've used Boolean operators because I want to make sure that CISG and the conventional international sale of goods are referenced. I haven't taken note. There might be a French document, and I'm afraid I need to look up what the French name of the document is, but I could say or and then include the French name or something to that extent, so that it's clear that you're looking for something across languages, because especially this will probably lead you to English language documents, and of course there are many more in the database. And using filters, I haven't shown you this, but this is more or less, let's say, the advanced search where you start off doing a research. You can also use those, for instance, combining awards with the search for terms up front. But as I showed you, I did it through a combination of searching and filtering, post-search filtering, that is. I hope that answers the question.
Oh, I think that's perfect. And a follow-up question immediately came in on that search. So the section or the category awards, does that only cover real awards, or does that also include excerpts of awards that were published in a journal, to the extent that that actually exists? So the Icar yearbook, of course, in a sense is a journal. I mean, it's a yearbook that comes out on a yearly basis.
Exactly.
But if we imagine that an award was published in full or in excerpts in one of Kluwer's journals, or in another journal that's included in Kluwer Arbitration, Kluwer Arbitration, as I understand now, we would also more and more journals would show up in that search.
Absolutely, yes. So the awards category for us is anything that roughly resembles an award, and that can be an award in full, so in other words, just the full document, or it could be an excerpt of a meaningful excerpt, so not just a paragraph, but a meaningful excerpt, which could be several pages long, or it could be, in the case like you just mentioned, Stefan, in the yearbook, a redacted version of the award where crucial parts of the information have been omitted or changed for confidentiality reasons, but it still constitutes, to a large extent, the main thrust of what the original award was.
That's great, thanks.
What I wanted to show you now that I've done a search, because as Mona was saying, it's good to take note of what you've done, and you may want to jot down, okay, I've combined these search terms, but we actually have we don't have a save option, because a lot of our customers are using Kluwer Arbitration via IP, and so it's very difficult to personalize searches, but we've done what we think is the next best thing. So if you've done a search, you can use the URL option. You can copy this into your notes, and by going back, by following this URL, you are going back to the exact same search that you've done. So in other words, CISG and convention for the international sale of goods. It may not give you, it will never give you less than a 21 that you just found. It might give you more, because as we grow, more might be added. If that's of interest to you, so in other words, you want to be kept abreast of when more content is added that meets your search criteria, you can use the RSS feed. Copy this URL into your RSS reader, and that could well be Outlook, but there are others. And you will be notified via email when new content is added that meets these search criteria. So again, that's something that may also be of use for you when you're doing your research, because otherwise it can be quite cumbersome to take notes of what did I do, which search did I implement. So I was saying, again, you can just start with typing and you can use your Boolean operators to do so. You can also search by doing a combination of the filters up front. So you can do pre-searching and post-searching. You could indeed say, I'm just interested in awards, or just in court decisions. I'm interested in maybe court decisions from one or several jurisdictions to make that search all the more powerful. You can search by party names or by court names. You can put in, if you have, for instance, a case number that you're looking for, it's often useful to put that into the words in title field so that you can search specifically for that case number. Again, there's various things that you can do here that really will have a significant impact on your research. And I have showed you there's also a browse option for many of these, just to make it a little bit more insightful, because a lot of people find filters somewhat daunting. So for the awards, here too, you can say, okay, I'm interested in any awards that we have in the database from the Arbitration Center of Mexico, and then we'll bring you a search result, and then you can also, for instance, say, I'm interested in any of the awards published that were completed under the tribunals, under the SEC rules. And you'll see that we have 47 SEC awards from various sources. So that's a way of using the browse option. The same is true for court decisions. Rather than going into the filters, you can say, listen, I am interested in, let's pick one, an interesting one, the Commercial Court of Brussels. We have 8 court decisions from various sources from the Commercial Court of Brussels. And once you've made this selection, you can always go into the search and search within these results. Maybe well, unfortunately, that's not right. Let me just take this out. In this case, there are no results for court decisions from the court in Brussels that discuss confidentiality. Apologies for that. That was just a random exercise. But again, this is how you could go about seeing whether this particular court has discussed a particular matter in any fashion. We also, in addition to the handbook, we have jurisdiction pages to make research into jurisdictions and also organizations more insightful. So for instance, if I wanted to know what we had on Sweden, again, taking the SEC as an example, it brings you to a neat page that gives you a quick insight into what we have on Sweden. So there's a link to the national report that I mentioned in the Icar Handbook, legislation generally from the Icar Handbook, some information on multilateral treaties, and then here you'll see Explora content where we have all the court decisions, the legislation, the commentary, and the bilateral investment treaties from this jurisdiction. So Kluwer Arbitration is much more than just a collection of books and journals. We have a lot of ancillary materials or primary source materials as well. We also try and give, where possible, recommended reading so that you can, again, deep dive into a certain matter. Although personally, I would always start off with the national report just because it's more succinct than reading through a 400-page treatise or thereabouts. And the same is true for the organization. So for instance, if I wanted to see what we have on the LCIA, just as an example, you have, again, commentary on LCA provisions, copies of various LCA rules, whether they're in various languages or from various versions. We have awards from the LCA that we've been able to collect. And in the case of institutions, also some model clauses. But here too, recommended reading if you really want to deep dive. I don't want to spend too much more time, but I did want to show you the compare jurisdictions tool, because both Stefan and Mona were stressing that international comparative research is just crucial. So we were talking evidence before, and you'll see that this is indeed covered. It's part of the standard structure of the Icar Handbook, where evidence is discussed, and you can select evidence, and maybe you wanted to do more or less. You can select whatever you like, and then select the jurisdictions for which the handbook has these national reports, and you can see what they have to say on the topic that I have just selected. And remember, this is something that you can use time and time again. It's not just when you draft the contract, but it's across the line whenever you want to, familiarize yourselves with how a law prescribes or how people may expect certain matters. This is where I would deep dive. And you'll see that these three reports, you get the section on place of arbitration, as I just selected, and you can read up on that. You can go, if you wanted to, you can go to the source page, and it takes you exactly to the section within the document that you were reading up on place of arbitration.
So Vincent, we have one question that I think is very fitting when we talk about this compare jurisdiction tool of the handbook. Now that's a tool that is specific to arbitration legislation or the law of arbitration as it is in place in different jurisdictions, and the handbook compare tool allows you to compare.
Yes.
How confidentiality would be addressed in China as compared to Canada, or how the determination of the place of arbitration is done in Argentina as compared to South Africa.
Mm-hmm.
And we had a question of whether Kluwer Arbitration provides a tool generally to compare legislation. So
on a more provision by provision basis, you mean?
Of a more provision by provision basis, and not specific to arbitration. So let's say comparing how a contract is concluded in English law as compared to Saudi Arabian law. Something like that, that's not on Kluwer Arbitration, I understand. So we have a compare tool for arbitration-specific issues, but not a comparative tool that would relate to just any legal issue in the world. Okay,
no,
I think that's important to also keep in mind what the limitations
absolutely
are. These are arbitration-specific issues, and then Kluwer Arbitration, of course, also allows you to research into issues that regularly come up in arbitration as matters of substantive law, but it's not a general comparative tool for any comparative exercise that you may be interested in. Even outside the context of arbitration.
No, absolutely. It's very much a well, it is what it is. It's arbitration in the narrow sense, and that is both commercial and investment arbitration. But it's, as you say, the focus is very much on arbitration, and just general contractual matters aren't necessarily covered. I don't know, Stefan, were there any other questions at this time?
So I do have two further questions, but I would direct those to Mona. That depends a little bit on whether you still wanted to show us some navigational skills on the web.
I'm aware of the time that we've passed, so I wanted to highlight just a couple more special focus areas. So we have a section on the website, which is the bilateral investment treaties web section, where you can see in the context of investment arbitration, what bilateral investment treaties are in place and what provisions they undescribe. So that's a useful tool. So you can say, for instance, I wanted to know if Albania has concluded any bilateral investment treaties with, let's say, Belgium or Denmark. You can see the treaty here. That's the way of getting to that treaty, and you can play around with that at leisure. The other thing that I wanted to show you, I guess, is the various means of staying up to date. I showed you that you can subscribe to either an RSS or you can copy a URL when you're doing research. The blogs that we have both on arbitration and on a secondary level, the mediation blog. We mentioned already that the Young ICCA posts are selectively republished in the arbitration blog. The arbitration blog is much broader than that, but I could, very much recommend for a weekly or a daily doses of developments. The arbitration blog is invaluable. And then the ITA arbitration report, which is also quite useful, but maybe for the more people that are a little bit further down the track. This is our way of showing you new cases, well, new, I should say, relatively new jurisprudence from around the world that we collect with the assistance of the ITA Board of Reporters. Again, jurisprudence from around the world, focusing very much on the more interesting substantive decisions that are rendered around the world, so that you have that at your disposal. For me, that's what I wanted to show you in the nutshell. I mean, there's maybe more if we have more questions, Stefan, but for now, this is it.
Yeah, great. So I have one question that I would direct to you, Vincent, and then a number of questions for Mona. So yes. We've had questions that relate to research concerning institutional rules. Is it possible through the database to find specific case law and how specific institutional rules are interpreted by tribunals or by courts? And if I see this list of institutions, it's large. So is there a way for me who doesn't know these institutions to find out which ones are important and how many cases they actually produce or how many awards they render? Does Kluwer Arbitration provide an answer to that?
We don't provide an answer because, first of all, I mean, the definition of an important, I mean, more popular, sure, we could make a short list, but these are institutions that we have in the database. The only way of making a selection is seeing how many awards that we have in the database, and you'll see that if I do a search by award, that there are quite a number of awards in the database, and then you can say, okay, show me which organizations are these from. So you'll see we have quite a number of ad hoc, ICDR, CAS, the Russian Chamber of Commerce, Cairo, etc., the London Court of Arbitration. But we don't have a way of really highlighting what the more important ones are. There's about 24 that I know are really important or most popular, but we don't have that highlighted somewhere on the website.
So, but I think this tool that you just showed us, I think gives a very good indication of sort of, how the numbers are and, what's also reflected in Kluwer Arbitration, because Absolutely. All the various sources that contribute to Kluwer Arbitration, whether that's ICCA or some of the other sources that provide arbitral awards, of course, also try to make sure that it's not just any unimportant award that, ends up in a database, but something that actually has some legal value.
Exactly.
And the database or the search tools provide you a possibility, if it exists, also to find out what arbitral awards or courts say on how to interpret specific institutional rules.
I would think that it's for court decisions. That's a challenge. I think it's probably something that you would do through searching. So if I were to say, for instance, I wanted to know what court decisions and I'm assuming that, maybe I'm wrong, but I'm assuming that you're looking from court decisions from a particular jurisdiction on what they would say on a particular topic. But if it's more general, you could say, okay, court decisions and let's say LCIA or London Court of International Arbitration, and then you would see that there are 203 court decisions in our collection, at least, that have commented in one way or another on LCAA, on LCAA
and you would then
rules.
narrow that down.
Exactly,
Down to
I would
whether...
narrow those down based on maybe additional, because I mean, just mentioning the LCAA, I mean, depends on what
specific
provision,
rule
that you're interested in. Doing that would narrow it down further.
Okay, great. Let me maybe ask Mona a few questions that came in through the chat. And one was, Vincent mentioned it already at the beginning. So he said, you know, Kluwer is, of course, not the only database. It's important, but it's not the only database. You should also check other sources. What other databases would you, Mona, recommend, you know, the researcher to consult?
I mean, there are a wealth of resources out there. I think the question was also asking which ones are open access, and that's where it becomes a little more difficult, because a lot of these resources are not open access in that you do need to pay a charge to access them. So things like, you know, LexisNexis, Practical Law, and a number of other very, very helpful research platforms, and that's largely because they are more geared towards practitioner use than student use, for example. So, you know, it costs a lot of money to carry out this research and to keep those databases up to date. So naturally, that cost gets then passed on to the user. But one resource that it's worth having on your radar that that will hopefully become available, and this is on awards, is that the IBA Arbitration Committee a couple of years ago created a subcommittee on international commercial arbitration case law, and the aim of that subcommittee was to collect international commercial arbitration awards and to periodically publish reports about them to make this available. And they've actually now partnered with Gismundi, which is another very good arbitration research database. And Gismundi will be making the awards that have been collected by that IBA arbitration subcommittee publicly available. So that's a really great development, and one that's a case of just watching this space to see when that actually goes live. And when it does, I think you'll all find it useful. I'm not sure if maybe it's already gone live, Vincent.
Not that I'm aware
So
of.
it's going to, I think.
The other source that I can think of that is a free source, but unfortunately is only investment arbitration, is ITA law, which is Andrew Newcomb's website. And he has a wonderful collection of investment decisions, also court decisions, but primarily decisions by arbitral tribunals, and they're all in the public domain. But I think that's also the nature of investment arbitration, is that because they are state sponsored in part, they have to be public. Commercial arbitration, by definition, is almost is always confidential, and then there's a few exceptions for publishing. And I can't really think of anything else that is in the public domain, at least.
I think my prediction would be in general that more and more also commercial arbitration awards will become public in the future. You see a variety of different institutions pushing for transparency, a variety of different actors, you know, whether it's NGO, whether it's party business associations, whether it's the arbitration community pushing for more transparency. So, you know, a few years down the line, we may not be facing that problem anymore, that there's too little in the public domain, but that there's maybe too much in the public domain. And at least at, you know, Icar Publications, one of the key roles that we see for ourselves is to then actually sift through the existing material and make a selection as to what's important and what's not. So to, you know, separate the wheat from the chaff.
And there's also,
Mona,
oh, sorry, go ahead.
One other, I think, you know, really important question, you touched upon it, and Vincent in his presentation also touched upon it, is multilinguality. Now, we focus, of course, a lot on English because that's the lingua franca of international arbitration. But still, domestic courts that have something to say on the relevant conventions, they render their decisions in whatever their local language is. Some of it gets translated, including in the Icar yearbook, but much will not. There's also writing in French, particularly in German, in Spanish. Now, how should a researcher deal with multilinguality? And how should he or she deal with it, particularly when not too familiar with the language and the underlying jurisdiction? So are translating tools like Google Translate, machine translation tools, something that one should rely on at all in doing legal research?
So I'd say for anything like that, if you're looking at what the position is in a particular jurisdiction and what approach they take to certain legal issues, then as Vincent's demonstrated, you can look at things like the Icar country reports or use Kluwer's comparative tools, and there are other bodies and websites which offer that kind of information. You can, of course, use Google Translate if you wish, but I would just say you really need to use a lot of caution when doing so. You can't entirely rely on something that's as crude as the Google Translate tool. And we know in law how much turns on linguistic nuances. And in particular, words that can have a very specific legal meaning in their original language. If you translate them into another language, you may lose that nuance when you're using something like Google Translate. So I'd say that was helpful just in terms of getting an idea of what an article is about, or getting an idea of what a decision from a court in another jurisdiction in another language was about. But really, if you want more than that, if you want to be able to really rely on that source, or you want to be able to cite to it and quote from it, then you really need to either get that properly translated or seek advice from local counsel who's familiar with that jurisdiction's laws and practices. So unfortunately, the shortcut of using something like Google Translate, I'd say, is really only helpful to give you a sense of what the document is about, but don't rely on it beyond that. And certainly if I was going to cite in a submission to a paragraph or a passage from a document that was not in the language I'm familiar with, you would always want that to be professionally translated, not just rely on something like a Google Translate.
And I think this issue of multilinguality, of course, also points immediately to some of the limits that particularly smaller, local firms, firms that aren't international, firms with counsel that do not speak many languages and have not, abundant experience in multiple jurisdictions actually face in international arbitration, because truly international cases usually span multiple jurisdictions, languages, also legal traditions, and then some of the bigger firms, of course, have advantages. Mona, one other question was related to access or problems of accessing material. What should a researcher do who is pointed through various research tools to a specific source as particularly authoritative? So be that a journal article or an award or some other source, and access can't be had. What to do in such a situation, particularly if there are close deadlines?
So largely, of course, it's going to depend on why you can't access it. Is it something where, for example, you have seen a reference to that, to say it's an award, or and you've seen a reference to it in something someone has written, but you haven't been able to get a copy of the underlying award? Now, in that case, the best you can do is to include the citation to where you saw the reference to it, remembering that when you put that in front of, for example, the tribunal, that it's up to the tribunal to attach whatever weight they want to any evidence you put in, and the hearsay rule isn't usually not an issue for you in international arbitration. So I'd say in that circumstance, you just have to do what you can. If it's something where you might be able to get a copy of that document but not in time, then it depends on what the document is that you're inserting the reference into. If it's a draft that you're preparing to share with a team member, then hopefully you'll have enough time to then go away and investigate how you can get hold of the underlying material. If it's a submission that you have to put into the tribunal, it may be the case that you can request permission to adduce that document later on in the proceedings once you've been able to get hold of it. So, but also I think this is really where managing your expectations comes in. You're not always going to be able to get hold of that document. That's the reality of it. And given the universe of materials that are out there on international arbitration, it stands to reason that there will be some things that you may not be able to get hold of, particularly if they are awards that somebody is referring to. And sometimes it can be quite oblique. Someone could say that they have seen an award in which the tribunal came to this conclusion, but they haven't cited exactly what that award is, because it's something that they have had sight of, but it's not in the public domain, and they can't give away, therefore, any details of even beyond perhaps which institution rules it was under, or what the seat of the arbitration was, or something like that. So this kind of comes back to the point I was making about how you're not always going to get a neatly packaged perfect answer, and you're not always going to be able to get hold of every single thing that you would ideally like to have.
And that's probably also one of the reasons why in most international arbitrations you also have to submit to the other party, to the tribunal, the authorities you're actually relying on, because there's not necessarily a common and shared understanding of what is authoritative. And what everybody should know, sort of as the canon of international arbitration. We slowly have to come to an end, but I would like to leave Vincent with one question and the request for a short answer. What does the Practical Insights tab actually hold on Kluwer Arbitration?
The Practical Insights is an addition, is a separate module that some people will have access to, and it's very much an attempt to do, on a comparative level, topic-based research, so that we have a very short introduction on third-party funding, enforcement of interim measures, confidentiality, fraud, corruption, those matters described in succinct detail by well-known experts, and then with additional materials to kind of deep dive further. So you will have either commentaries or jurisprudence that they've cited that they feel really gives extra background. So there's more, but that's the main focus of Practical Insights.
So it's 5:20. There are many more questions that come through the chat. I'm afraid we can't pose all of them. So people are interested in how to deal with redactions in awards, how that impacts their authoritativeness, what role the principle of proportionality may play in international investment arbitration. These are all fascinating questions, and maybe Icar, Young ICCA is going to organize another session on these. I think for now, what remains for me to do is to really, really thank Mona and Vincent for these insightful presentations, for answering patiently a number of really, cutting edge questions and questions that were, really on spot, not only for somebody who just starts doing research in the field, but all of these are really questions that you will grapple with over decades, and even some of the dinosaur or elephants in this field are still grappling with them. Thanks a lot, and hopefully come back for more. Young ICCA is doing a really great job with these webinars. Thanks a lot.